Since very few design or construction disputes are ever resolved by trial or a binding arbitration hearing, it's worth considering what is it that prevents these design and construction disputes, which eventually settle, from settling much earlier and on cost-efficient terms. And one of the first things that comes to mind is a lawyer's intuitions. In other words, what your lawyer is telling you about the design and construction dispute and how it's likely to resolve. There's a fascinating paper that was written in 2013 out of Cornell Law School. I think it was the Cornell Law Faculty Publications, entitled How Lawyers' Intuitions Prolong Litigation. It was written by a federal judge and a Cornell law professor. And there was empirical research reported in that paper concerning judgment and choice, and specifically why cases tend to settle on the courthouse steps and not earlier. And the authors considered several of what they called cognitive illusions, which produce lawyer intuitions, which cause them to delay real settlement discussions or possibly to reject good settlement proposals with the benefit of hindsight they might wish that they had accepted. And the paper goes on about how lawyers' tendency is to rely on intuitions, which magnify the impact of those cognitive illusions. And the authors prevent experiments showing the vulnerability of even experienced lawyers to these cognitive errors, which can prolong litigation. So one of the things that tends to prevent early cost-efficient settlement of design and construction claims, in my view, and this is something that I've certainly experienced a lot in dealing with lawyers on the other side, is what lawyers tend to tell their clients about what's going to happen in a design and construction dispute. Another key thing that tends to delay settlement of claims, which should happen earlier rather than later, is overconfidence of attorneys and parties due to selective attention of facts. And like many people, I'm an advocate. I can fall prey to this and this selective attention to facts, where I'm going to have, one eye closed and the other side is going to have the other eye closed, because we want to focus on the information which tends to help us as advocates advocate on behalf of our clients. But this overconfidence in the merits of our client's position leads to, I don't want to call it intentional blindness, but it leads to a certain lack of understanding about the other party's position and specifically why that position might be reasonable. So that's the second thing I'd like to talk about in terms of why these claims get settled, but they get settled too late and after too much expense. Paul Lurie, the father of guided choice dispute resolution, has taught me a lot about how personal and organizational goals and the quirks and the biases of people in institutions is also an important factor here. These are human factors. These are corporate factors and biases which affect why people choose to settle or not. And this can involve a wide variety of things that are well beyond the scope of this video. Risk tolerance, corporate culture, individual personalities of stakeholders and their biases, and many more. For example, in some institutions or in some situations, face saving may be very culturally important. And in other situations, it might be the case that some of the decision makers feel the need to avoid a perception, of losing either, to themselves or to others by accepting another party's settlement proposal rather than accepting on terms that they propose. It's the case that, corporations and government entities have rules which can be formal or informal about, how you negotiate to resolve these disputes, and, insurance companies being a great example. It's also certainly the case that early cost-efficient settlement of construction claims can be delayed due to things like, distrust, anger, fear is a big one, and antisocial or otherwise hostile behavior from the people who, are involved in these disputes. And, by the time a dispute lands on a construction attorney's desk, it's likely the case that there's some sort of a formal negotiation process that has to be undertaken because informal discussions have failed. In other words, we've had an escalation, okay? And this can be highly emotional for the project participants, and particularly those foot soldiers who have day-to-day project involvement, the people who, arguably caused the dispute. You can have angry stakeholders, and angry stakeholders can lead to angry lawyers. And the feeling of these people that they've been lied to or treated unfairly, or that there's some lack of good faith. And I think an important point is that it's almost always the case that those feelings are unrelated to the merits of the dispute. And yet, it's generally the merits of the dispute that the parties want to talk about in traditional mediation. It's one of the reasons why guided choice dispute resolution is so powerful, is it isn't so focused on settling the case or the merits of the dispute, but rather setting out a process which would tend to understand what are the inherent obstacles to getting to a settlement. What is the process necessary to remove those obstacles? Another thing that Paul Lurie has taught me to understand is that, the emergence of coalitions and an uneven flow of information between the various stakeholders in the disputes is another thing which tends to prevent early cost-efficient settlement of construction claims in mediation or otherwise. It's common in multi-party disputes for groups to gang up, to team up on some other parties involved in disputes. They might share or withhold information unevenly to various participants in the disputes based on various things. It could be pre-existing social or business relationships. And there can even be coalitions which emerge within a single company's set of representatives. It can be the case that lower level employees who are involved in creating the disputes might be interested in avoiding blame. They might be less than completely transparent with their bosses, the employer decision makers, who are going to make decisions to either settle or fight on. These lower level employees theoretically being more concerned about their job or their holiday bonus. So these coalitions can emerge even within one organization, which can have a really deleterious effect on the dynamics that would tend to put the decision makers in a position to make a smart decision to either settle or fight on as their strategic interests dictate. It can be the case when these coalitions emerge that it can be a perception of one party that the other side used tactics to sway the mediator, getting him or her on their side, and maybe leading to a perception that the mediator is no longer unbiased. And so shifting on to the last few things which can tend to prevent early cost-efficient settlement of design and construction claims, loss is a big one, and specifically aversion to a loss in the emotional needs of the stakeholders. I think that there's some fascinating science out there about the application of neuroscience to negotiation and conflict resolution. And I'm told, not knowing much about this beyond what I've read, that the emotional parts of the brain on one hand and the cognitive parts of the brain on the other are literally in a fight with each other for things like oxygen and glucose. And these emotional and cognitive parts of the brain can't work well at the same time. And I've read and I'm told that even the mere mention of the word loss, because it's widely accepted, I believe, that losses tend to weigh more heavily in people's mind than gains. The mere mention of the word loss can trigger in the amygdala a reaction that leads to emotional responses. And if you're more interested in this, I would say check out some of the writings and scholarship of Francois Bogaz, an academic and a mediator who I believe is active in France and Portugal, whose writings are fascinating and has had a great influence on me. But generally, this need to avoid loss and the emotional needs of the parties can lead them to act in ways which are antisocial or hostile or generally bizarre. And all of these things, this witch's brew of things which tend to prevent the early and cost-efficient settlement of design and construction claims, they're really just steeped in this environment of a potential for escalation and adversarialism. I don't want to make light of it, but the whole context of this is not a trip to a daisy farm. These are people who are, armed and they're eyeing each other and they're deciding whether or not to shoot, their bullets at each other, figuratively, I certainly hope, not literally. And not having a good process to address these issues is a real problem. It's a real obstacle to getting to that all-important, early, and cost-efficient resolution of design and construction claims on terms which are mutually agreeable to everybody, terms which are likely to be reached a year or two later after a lot of unnecessary cost and frustration. And this is the reason why I'm a big fan of guided choice dispute resolution, because guided choice focuses on the process that is necessary to deal with the wide variety of issues which go far beyond the merits of the dispute, which tend to be all the parties want to talk about, when it's often the case that the merits of the dispute are not the thing which is preventing the parties from settling. So I'm a big fan of guided choice dispute resolution for resolving design and construction disputes. And I hope you'll check out a few more of my videos and other resources, which are linked on my website, to the best thinking around guided choice dispute resolution.